Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer all these questions in today's video. Vocal crypto supporter John E. Deaton has hinted at what may happen if the U.S. Securities and Exchange Commission succeeds in its case against Ripple, the company that created XRP. Will Ripple be able to beat the SEC? The 2-year legal struggle between Ripple and XRP has been marked by significant procedural triumphs for Ripple, leading XRP fans to hope that Ripple would ultimately prevail. Annalisa Torres, the judge presiding over the case, may cause problems for many crypto-focused businesses if she agrees with the SEC's argument that all XRP transactions, including those on secondary markets, are securities. John Deaton claims that this is the case. According to Deaton, if the SEC wins, Chairman Gary Gensler will have the political support and momentum to file similar claims against other corporations in the digital asset area. In a tweet, Fox Business writer Eleanor Terrett offered some observations on the recent closure of Signature Bank, prompting the XRP attorney to respond. Significantly, the New York Department of Financial Services announced the closure of Signature on a Sunday with no explanation. According to Terrett, ex-Congressman Barney Frank's shrewd comments suggest that this was all part of a plan to convey a message against cryptography. One of the leading companies in the cryptocurrency sector, Ripple, has developed useful applications for blockchain technology. SEC's bombshell lawsuit against Ripple and 2 of its senior executives for illegally generating over $1.03 billion via the sale and distribution of XRP cryptocurrency in December 2020 devastated the nascent industry. The token's future hinges on the outcome of the litigation, which centers on the issue of whether or not XRP is a security. Crypto experts generally feel that Ripple is now ahead in the drawn-out legal fight. When the court declined to invalidate Ripple's primary fair notice argument last month, the SEC also suffered a loss. The judge's ruling, which is anticipated in June, will likely be a watershed moment for XRP and the cryptocurrency sector as a whole. Nonetheless, if Ripple is successful, XRP may challenge $1. With the completion of the highly known Securities and Exchange Commission (SEC) lawsuit against blockchain startup Ripple presumably inching closer, a pro-XRP legal expert has offered his thoughts on the case's likely outcomes. Likewise, in a March 10 Twitter thread, Scott Chamberlain, a former lawyer and co-founder of the permissionless Layer 2 platform Evernode, XRP, enumerated 5 probable possibilities for the lawsuit's resolution, including summary judgments, the prospect of settlement, and following lawsuits. In particular, the legal expert said that the regulator did not have anything near the evidence to demonstrate they intentionally or carelessly marketed an unregistered investment in the summary judgment phase involving Ripple CEO Brad Garlinghouse and co-founder Chris Larsen. About Ripple's summary judgment on foreign sales, Chamberlain noted that Ripple's sales of XRP on overseas exchanges are not within the court's jurisdiction, adding that an entirely new precedent would be formed to declare those domestic transactions closed in the U.S. Moreover, Chamberlain emphasized that this complaint might lead to a limited case that investigates whether any of Ripple's sales of the XRP cryptocurrency in the United States constituted an unregistered investment contract. In other news, New York Attorney General Letitia James filed a lawsuit against KuCoin, accusing the cryptocurrency exchange of unlawfully functioning as a securities and commodities broker, dealer without registering with the state, as Finbold reported. Scott Chamberlain, a former lawyer and co-founder of Evernode, a proposed Layer 2 smart contract technology for the XRP ledger, has published his 5 predictions for the result of the SEC action against Ripple. To begin, the co-founder of Evernode thinks the SEC will lose its case against Ripple executives Brad Garlinghouse and Chris Larsen. Remember that the SEC had identified the executives in their lawsuit against Ripple, accusing them of aiding and abetting the offer and sale of unregistered securities, XRP. According to crypto law, founder attorney John E. Deaton, the SEC, must demonstrate that the executives were reckless in failing to recognize that XRP was a security. The SEC, according to Chamberlain, lacks the evidence to substantiate this. Second, Chamberlain believes the court will rule that Ripple's offshore sales of XRP fall beyond the scope of the court's authority. The former attorney said that classifying them as transactions done in the United States would establish a new precedent. In his last forecast, the former lawyer claims that the only question is whether any Ripple XRP sales in the United States contained an unregistered investment contract. Because of his second and third forecasts, Chamberlain anticipates that the SEC will seek a settlement. According to the former lawyer, the SEC overlooked the fact that the majority of Ripple's XRP sales happened offshore. With the lengthy legal struggle coming to a conclusion, at least at the district level, it is predictable that speculation about its fate has reached fever pitch. Chamberlain's projections, for the most part, agree with Deaton's prior forecasts and analysis. Significantly, the attorney projected that there would be no out-of-court settlement until after a summary judgment finding to delay a prospective trial or appeal. Moreover, the crypto law creator has said that the SEC's only potential triumph would be if Ripple traded securities between 2013 and 2017. As a result, he thinks there will be no disgorgement or injunction on XRP sales, but Ripple may be required to pay a fine. One of the biggest headlines in the XRP community would be a relisting of the XRP token on the main U.S. crypto exchange Coinbase if Ripple prevails in its legal fight against the U.S. Securities and Exchange Commission. Exchange Commission CEO Paul Grewal, Coinbase's chief legal officer, CLO, has discussed the situation in depth and outlined the steps that would be taken to relist XRP. Trading of XRP was halted by Coinbase in January 2021, soon after the SEC filed its action, and has remained suspended to this day despite calls from the XRP community. While Grewal was optimistic about a Ripple triumph in yesterday's discussion with Thinking Crypto presenter Tony Edward, he made it clear that the subject of a relisting is not dependent entirely on whether or not Ripple wins in court. Grewal said that the U.S. cryptocurrency exchange continuously assesses assets to determine if they should be listed, delisted, delisted, or temporarily halted. He also has some comprehension of the XRP community's anguish. I realize it has been difficult for many XRP investors to be unable to trade their assets on Coinbase while this SEC lawsuit has been ongoing, said Grewal, adding that the SEC has not prevented Coinbase from closely monitoring the progress of the action. Grewal, like everyone else, is waiting impatiently for a judgment and has nothing but praise for Ripple's legal team. The defendants in this case have done a fantastic job pushing the SEC and raising major concerns about the SEC's overall approach, which is something I took note of. Some of Ripple's arguments were strengthened by this, and Coinbase even filed an amicus brief in their favor. Ripple CLO Stuart Alderety and the rest of the fintech company's team have done an amazing job. In Grewal's opinion, therefore, he has little doubt that Ripple will prevail in court. There will be a lot of problems shown with the SEC's theory. The trial judge's opinions on the arguments and briefs in this case should become clear very soon. The Coinbase CLO did note, however, that in his judgment, the ruling of the Southern District Court of New York is only the beginning of a rather prolonged process. In Grewal's opinion, it's quite probable that whichever party loses in court will appeal, and that the case will go through several rounds of appeals. Grewal stated that the trial court's judgment and the judge's legal rationale will determine how long it will take for Coinbase to relist the tokens, as well as whether or not the verdict would be upheld on appeal. So, much will be contingent upon the specifics of that court's ruling. Although Grewal acknowledges that this answer may disappoint some, he argues that the firm owes obligation to its shareholders to tread cautiously. In this area, and with regard to any token that is the subject of litigation in federal court. Finally, the Coinbase CLO promised that the exchange will begin conducting a review as soon as the decision became available. As much as everybody else, I cannot wait to hear the court's verdict and to share that as soon as we receive it, we will begin our process to determine whether or not we need to reconsider our listing decision.